Welcome, everyone, and thank you for attending today. We really appreciate you joining us today for the second in a series of COVID-19 credit union-centric events. First, I wanted to go over a few housekeeping items. Last time when we did this, it was a Zoom event. We asked folks to deal with cameras and with microphones. As it's a YouTube event this time, we're doing a little bit differently. That said, we still want to make sure everyone asks and we can answer everyone's questions. So please, you'll see at the bottom of your screen the ability to chat questions. We hope that everyone gets involved. We want to make sure this is interactive and everyone gets involved in the conversation. I also wanted to mention that today the event will again be in 4 sections. The 4 sections, I'll talk a little bit more in a few minutes. Each section will be about 10 minutes long, and these sections will cover the 4 areas that I'll talk about in a minute as well. Last, I want to say that although we're discussing serious topics today, we don't take ourselves too seriously. We want this to be a fun event. We want this to be an event everyone enjoys, and we want everyone to be involved. So please chat your questions, and make sure that you chat them to everyone. Jonathan Silverman, who I'll introduce in a moment, will be taking your questions. And at the end of the 4 presentations, the questions will be asked to our panel, and hopefully we'll be able to answer everything you ask. Let's begin with introductions. I'm joined today with by my law partner, Milt Seiladw. Hey, Milt, how you doing today? Milt, can you hear me? All right. Let's move on. Also joined today with Seth Berensweig from the law firm of Berensweig Leonard. Seth, thanks for joining us today.
Gary, my pleasure.
Great. Ronald Cantor from the law offices, Ronald S. Cantor, was supposed to join us today. He had an emergency and cannot join us. We'll cover his slides today as best we can and move forward after that. Also with us today are Kevin Fitzpatrick and Jonathan Silverman from the Capital Group. Thanks for joining me, Kevin. Thanks for joining me, Jonathan. Appreciate your taking the time.
Thank you, Gary. Pleasure to be here.
Let's move on to the slides. John, there you are.
Yep, glad to be here, and thanks for letting me join and help out. If you have any questions, please chat them in the YouTube comments, and I'll be reading them from my phone after everybody is done presenting.
Thanks, everybody. Let's move on to the slides. Start with slide 3, please. Actually, slide 2, please. So as we discussed in the last meeting where we talked about how things had changed in the last 30 days, today we'll talk a little bit about how things have changed in the last 60 days. How we live, how we work, how we do business, and how we interact with our coworkers has all changed. Since we last spoke, an updated poll has given us more information, and it's not great information, but approximately 1/3 of the folks that were polled throughout the United States have answered polls saying that they've taken pay cuts and significant pay cuts to where they'll have a shortfall in paying their monthly bills. 53% of those who were polled said that they did not have enough savings for 3 months, and at the end of those 3 months felt that if they weren't fully back to work, they wouldn't be able to pay their monthly bills and buy food and do the things they needed to do on a regular basis. Unfortunately, the unemployment numbers aren't much better. Since mid-March, over 30 million Americans, roughly 20% of the workforce, have filed for unemployment claims, making it the largest and most dramatic rise in claims on record. That said, today we'll look at 4 areas. Recent actions taken by state and local authorities, new credit reporting challenges that result from CFPB and state actions, recent changes that impact employee benefits and their funding, HR updates related to the CARES Act, paid sick leave, family leave, and the new Virginia Values Act. Let's move on to the next slide, please. So I'm going to have my partner, Milt Seiladw, go through these slides. Milt, let me hand this off to you, and you can discuss the changes in the state of Maryland, District of Columbia, Virginia, and Massachusetts. And I know you also have some off-topic matters to discuss as well. So why don't you take it away? I'm sorry? Okay. I'll take the slide. Okay. Why don't you switch to the slide, please? No, I'm sorry, last slide, please. Thank you. Last slide, please. Thank you. So to deal with the situation that's going on and everything that we've seen that's gone on in the last 60 days, there's been significant movement in the courts, in the state governments, in county governments, and to some extent the federal government. So let's go through what we know is happening in our area and talk a little bit about what recently happened in the Commonwealth of Massachusetts. So in the state of Maryland, as most folks know, an executive order was put in place where all foreclosures, evictions, and repossessions have been suspended by both original creditors and debt collectors. Court hearings, except involving criminal, family, and requests for injunctions, have been suspended, and new filings are being accepted electronically but not being heard. In a recent executive order, banks and credit unions are barred from attaching and sending off against stimulus checks, but a order that came out recently informed the folks in the state of Maryland this applies to only state chartered credit unions in the state of Maryland. In the District of Columbia, the most I can say is that everything has been closed down for this time of the emergency plus 60 days. All courts are closed except for emergency hearings. And recent guidance has told us that the courts will be open again on the 14th of July. We don't know if that's actually accurate, as we expect that we'll get further guidance at a later date, letting us know that the courts will be closed for a further period. We expect the District of Columbia will be closed longer than anyone else. And as far as Virginia is concerned, you'll see at the bottom of this slide, and I believe also on YouTube, a link to the courts all around the country, state action all around the country. And you can check that link as Virginia courts are moving on a county by county basis. So you'll get better information on what's going on in those counties and know what's going on as far as the courts are concerned and what those county actions are. Last item I want to discuss on that former slide is the state of Massachusetts and what's going on there. In the state of Massachusetts, there was a federal court ruling that in the form of a TRO, a temporary restraining order, that barred the state from ruling as to whether or not collectors, third-party collection agencies, law firms could make debt calls. As you may recall, the Attorney General of Massachusetts made a determination that no debt calls could be made in their state, and an action was brought for the purpose of challenging that. And the federal court ruled on constitutional grounds, on free speech grounds, that you can't bar folks from making phone calls. The reason why we bring it up and the reason why it's in the slides today is because we are hoping that similar action will be brought in the District of Columbia and other jurisdictions. The other reason why I bring it up is because when we look at the next slide and talk about what's going on in the federal government, we're hoping that potentially the courts will keep the legislature from doing things that may chill our ability to collect funds and our clients' ability to collect funds. If we can go to the next slide, please. Oh, okay. Milt, you're here.
Hey, Gary, how are you?
I'm fine, thanks. I lost you for your slide, but I'm going to pick you back up when we get to Ron's slides, okay?
Sounds great.
All right. If we could go, please, to the next slide. Perfect. Yep, that's great. So currently under consideration, which we did not talk very much about last time we spoke, was H.R. 6379 and, of course, the Senate corresponding 3565. We went through it quickly, but I wanted to spend a little bit of time. This is a bill that basically seemed like it would be the next stimulus bill and potentially could be the stimulus bill they're currently referring to Stimulus 3.0. What we know from this is, and if this language finds its way into the bill, what we'll see is that original creditors will now be defined as debt collectors. A moratorium will be placed on all debt collection for 120 days past the emergency date. So if the government declares emergency through September, that would be no bills can be collected by original creditors or us or collection agencies for the foreseeable future, hopefully or potentially until 2021. The FDC violation fines in this situation are now multiplied by 10. And in theory, to compensate for the losses banks will take, the Federal Reserve will set up a fund to pay the banks for their losses. Unfortunately, this won't be available to credit unions, so the credit unions will need to absorb their losses. We're not really seeing a lot of movement in this bill. Congress is not in Washington, and it's not something they're considering. Our concern is, as I mentioned, is that this language finds its way into the next stimulus bill, and it's easy to bury 14 pages of this into 1,500 pages of a stimulus bill. We're hoping it doesn't happen, but we're certainly going to keep our eye on it and keep everyone updated. Let's move on to the next slide, please. Okay. So the reason why I thought it would be a good idea to have this event was to talk a little bit about what credit unions should be thinking about during this event. And I'm going to go through this slide quickly, but I want to go through it and make sure everyone understands. So I think credit unions really need to start thinking about creating new policies to deal with members' hardships, provide new guidance concerning settlement and extended payment plans. Despite the debate over whether stimulus checks can be attacked or not attached, 22 states' attorneys general have sent a letter to the consumer reporting agencies, letting them know that they wouldn't hesitate to come after them, to file claims against them for how claims were reporting. And the same attorneys general has said the same thing about stimulus checks. It doesn't appear as though the federal government will take any action on stimulus checks. So it appears as though these states' attorney generals are happy to take this action. That being said, I think folks need to start thinking about balancing credit and collections versus how they're going to approach credit and collections after this event is over. Is it a good idea to file 200, 500, 600 lawsuits if you've been holding lawsuits since then, or sending 2,000 collection letters after this event ends? More importantly, how are you going to deal with the folks who are calling in with hardships, because those stimulus funds are only going to go so far. Once those funds are gone, then how are these folks going to pay their bills, and how are they going to deal with these situations? So the one thing that I would have folks bear in mind is that as we come through this and as we come out of this, we need to start thinking about new policies and new procedures to get through this. And I'll leave one last thought here, and that's I think credit unions need to start thinking about what they're going to do when they start to bring folks back. Everyone's worried about their health. Everyone's worried about getting sick. Everyone's worried about whether they have insurance to cover these illnesses that people are brought back too soon. And the policy you come up with on bringing folks back and how you deal with the folks you're dealing with as employees or members, that needs to be part of your equation. I'm going to move on to the next slide, which are Ron's slides, and let's go forward from there. Excuse me, didn't mean to do this as a marathon. So on March 27th, the CARES Act amended the FCRA and imposed new credit reporting requirements. Basically, those credit requirements require that you report everything as it was last reported on the day that on the day that this event happened, and they're setting that in January. So if you have someone reported as 90 days then, you're reporting them that way now. If you have someone reported 30 days then, you're reporting them that way now. Now, the other part of this is if folks call to make an accommodation and want to come through into a payment plan or adjust a current payment plan, the expectation is you will take that. It must be in writing. And once you take that, you will then be reporting that information either as current or the last way that it was reported. Now, the reason why this matters to our credit union clients is because obviously this is a law that applies to, or this is a change to the law that applies to credit reporting. Unfortunately, how you report to them is going to be important so that they can report this properly. And what you don't want to have is a situation where you're reporting it wrong and then have a credit reporting agency come back to you and say, well, I just got this information from them. Can we go back to the slide, please? Thank you. The CFPB has weighed into this in that they're taking, they have some mercy on the credit reporting agencies and fully understand that they're people too and have people working for them too. So as far as dispute resolutions is concerned and how they deal with dispute resolutions, what they've come about and said is they're going to be a little bit lax on how disputes are handled and the way disputes are handled. And of course, that's elicited 22 attorneys general saying, yeah, no, don't do that. We don't care if your people get sick. Just make sure that they do what they're supposed to do. That might be my interpretation, but at least that's all I can say about it. Let's move on to the next slide, please. So as I discussed, there's tension obviously between the attorneys general and the CFPB. Again, the attorneys general want everything done as it was supposed to be done and the way it should be done, and in requirements that are according to the new changes to the FCRA. And of course, the federal government's position is they're people too. Let's cut them some slack. We don't know where this will end up, and we're not really sure how this will end up. What's interesting about it is that everyone is working towards a goal. We just don't know what that goal is. And at this moment in time, they seem to be a bit divergent, but we think they'll come together. Next slide, please. So the next slide talks about where the CFPB is headed. And I'm just going to read that real quickly and then let Milt jump in. So they're talking about some rule changes, and you can look through the points and see what those rule changes are. The most important thing that we really want to talk about, and I'm going to let Milt talk about this a little bit, is the Supreme Court's considering whether CFPB structure as single director and removable for cause violates the Constitution. Obviously, there was a case about this recently, and notwithstanding what the CFPB plans to do or how they plan to do it, there's obviously going to need to be some change to their structure. There's going to need to be some change to how they do business. And I'm going to turn this over to Milt and let Milt talk about the Seiladw case and explain a little bit of what went on there.
Thanks, Gary. As Gary was indicating, that this case is Seiladw versus the CFPB. It was heard in the Supreme Court on March 3rd of this year. We don't expect a ruling till June, especially during this COVID-19 situation. But really, the issue was whether or not the CFPB structure was constitutional and that their director could only be dismissed for cause. Now, you had the extraordinary situation where you had the collection law firm in California arguing along with the Department of Justice saying that the CFPB structure was unconstitutional. We'll see where that ends up, but really, there are several options that the court can take. They can determine that the statute establishing the CFPB is constitutional. They could rule it's unconstitutional and sever the cause removal provisions. They can sever that provision and let the law stand, or they can determine that the CFPB has no constitutional authority to act, which, for collection agencies and financial institutions would probably be the best solution or best outcome, I should say. That's really where we are. We won't know what's going to happen with the court's ruling until the decision gets published in June. But, I'm sure we'll have another webinar to cover that in the near future. Right now, I'd like to pass it off to Kevin Fitzpatrick, who will talk to us about insurance issues during this time.
Well, terrific, Milt. Thank you very much. I'm Kevin Fitzpatrick from the Capital Group. We're an employee benefit and registered investment advisory firm located here in Washington, D.C. We specialize in working with the credit union and the nonprofit community. Gary invited me to talk for a few minutes here today on a COVID-19 update as it relates to insurance. Couple of things here to discuss right off the bat. Carrier premium relief is still on the table. Most of the major insurance carriers have put forth the ability to get premium relief without interest and without penalty. If you haven't taken advantage of it yet, it's certainly something to consider and to reach out to your insurance consultant or your broker about. Since the last time we spoke 30 days ago, several of the carriers, primarily being led by MetLife Dental now, are actually offering proactively 25% refunds of premium in regard to dental insurance. If you think about it, it makes a lot of sense. The dentist's office have, for the most part, been shuttered over the past 60 days. Their members have not had the ability to seek services, yet the insurance carriers have continued to collect premiums all throughout that time. We're hoping that we're going to see other large dental firms follow suit. PPP loan repayment strategy. Now, why is this important in regards to premium relief? We know that if you took advantage of PPP, once the check arrives, you have approximately 8 weeks to spend down those funds. And those funds can be spent 75% on payroll, 25% of those funds are allowed to be spent on fixed expenses, with healthcare being included in that. However, if you're taking advantage of premium relief during your 8-week window that you have under PPP to spend your money, that means you are not paying premiums. And that brings in the possibility of that portion of the PPP loan being not forgivable. So you want to make sure you have your timing correct and your strategy well in hand as it relates to seeking premium relief and or taking PPP money at the same time. Now we get down to the bottom of this slide, and this is what a lot of folks have been asking questions about. Healthcare projections for 2020 and 2021 in a COVID-19 environment here right now. We are anticipating a dip in the second quarter of claims. Once again, it follows along that same theme that elective surgeries and other visits to the hospital and physicians' offices have been put off. Those visits just have not taken place. So as a result, there's going to be a lag in the claims pipeline. Now, whether or not we see an uptick in the third and fourth quarter claims has yet to be determined. And of course, what is the impact of COVID-19 going to be on healthcare renewals? Next slide, please. One of the silver linings in the cloud here of COVID-19 from a corporate healthcare insurance perspective is that a lot of the individuals who have currently been impacted right now as far as hospitalization visits go have been disproportionately weighted to the elderly. And the elderly primarily are outside of the corporate healthcare ecosystem. They are covered by Medicaid or Medicare, and we anticipate those two payers to be bearing the brunt of the cost of COVID-19 related services. Now, with that said, we still don't know what the summer and fall is going to bring as far as impacts on folks in the 65 and under range there. But we are still anticipating a trend in medical inflation at the second half of the year and beyond to be in that 6 to 8% range there. Factoring in carrier profitability on top of that, once again, we're looking at double-digit potential renewal increases in the 10+% zone. What does all this mean? It means that in the second half of 2020 and in 2021, employers are going to be required to think outside the box. Premiums and renewal increases are not just going to be passed along. They're going to be scrutinized and they're going to be questioned. And it brings into play then, what other different strategies can we deploy to help control the cost of healthcare in the credit union and the nonprofit community? Because what we're looking at here is a potential intersection of a decrease in revenue, and this is just not specific to credit unions, this is to the business community in general, a decrease in revenue without a corresponding decrease in the cost of healthcare. In other words, you're bringing in less money, but the cost to insure your employees has either stayed the same or increased. And that pressure is going to force folks to revisit some of the strategies here that we'll talk here in a minute. Rob, can we go over to slide 12, please? There's going to be a lot of folks here now who are insured on the left-hand side of this screen. This is a fully insured ecosystem. These are the plans that we're all used to, from Care First, Blue Cross Blue Shield, Aetna, Cigna, United Healthcare, where you pay the same premium month after month after month, year after year after year. And then at the end of that cycle, you get a renewal and the price goes up and you rinse and repeat. And there is no participation whatsoever if you've had a good claims year or not. In other words, they don't give you any money back if you had a better claims year than what they anticipated. Moving from left to right, we have a lot of folks entering into what we call the level funding ecosystem. If you can envision a healthcare plan, I'll use Blue Cross Blue Shield as an example because they're a very popular carrier here. Care First is in the Washington, D.C. area. That looks really similar to the type of plan you have nowadays. Same copays, same hospitalizations, same networks. However, level funding plans give you the ability to participate and receive a refund of unused premium. In other words, if you had a better year than what Care First, Blue Cross Blue Shield thought you were going to have, they're going to give you all of or a portion of those unused premiums back. Basically, it brings your experience into play. And the upside to these plans is that if you have a terrible year in terms of healthcare, they're not going to come back and ask you for additional funds. Level funding plans also enjoy a more favorable tax status than fully insured plans do. There is roughly a 5% arbitrage or delta in your premium when you leave fully insured and go to level funded plans. You save 5% in taxes that you don't otherwise have to pay as a result of the Affordable Health Care Act. You're not paying these taxes separate right now. They are baked into your premium, which may be a surprise to many folks, but they're already in there. Now, moving further over to the right, this is where we get into even some of the more sophisticated strategies of self-funding and what we call graded funding. These are primarily reserved for folks in the 150 to 200 employee size range. So the larger credit unions, many of them are already engaged in this. However, the industry is dropping that number down. And there's a significant cash flow advantage that comes with graded funding and self-funding. Time today, unfortunately, doesn't permit us to get deep into that, but we're happy to discuss level funding, graded funding, and partially self-funded plans offline and follow up with anyone here. Now, with that said, that brings me to the end of my presentation here, but this is going to, again, put additional pressure on revisiting what's called pre-funding strategy. Credit unions are very unique in the sense that they have the ability under Regulation 701 of the NCUA regs there to take advantage and pre-fund parts of their healthcare. And with that said, I'm going to bring Jonathan Silverman into the conversation to take us through what a pre-funding healthcare strategy looks like and why it's bubbling up to the surface once again as a hot topic of discussion. Jonathan, take it away.
All right, perfect. And thank you so much for that great setup and intro, Kevin. Like Kevin introduced me, I'm John Silverman. I work with Kevin over at the Capital Group. And I'm just going to tell you a couple different strategies on how we can actually combat those premium increases that Kevin touched on briefly. So like Kevin said, in 2003, the NCUA amended Regulation 701.19, which gave federal credit unions the ability to take some of their reserve and invest it into what's called a non-permissible investment. A non-permissible investment isn't a scary term. I know it sounds a little daunting, but what that really means is that instead of investing in the traditional bond fund, which yields around 2%, it allows you to invest into REITs and other funds within the market, which might return 4 to 6 to even 8% returns. That sounds like a great strategy and a great program. A lot of credit unions would look at that and say, wow, this is a great way to make a profit. But the NCUA actually put specific things that you could use this money towards, and it essentially can only go towards and fund your employee benefits. So what employee benefits entails is employee group healthcare, your 401k matching contributions, your long-term and short-term disability or your ancillary products, as we call it in the insurance world, your dental and vision insurance, And if you have a benefit pension plan, it can also go towards those investments. So you might kind of be thinking to yourself why this might be a good idea to talk about and even bring up in the current state of everything that's going on during this pandemic. And on the next slide, I'll actually show you why this is a great time to invest. So Rob, if you could take me over to the next slide. Perfect. So the next slide speaks about a little bit why this might be a good idea for right now. So traditionally during pandemics, we actually see the market take a little bit of a dip, as you might have noticed in the past couple months. However, it always comes back. The market always returns and bounces back. We're at a low point right now. So taking some of your reserve, even if it's a small amount, and throwing it into the market would actually return a higher yield than you're used to in a 2% bond return. What can this be used for? So it can be used for your employee benefits and helping companies become budget neutral, but it can also be used to enhance your benefits. So a young person in the field right now really looks towards, when they're going to work for a company, what benefits they can get. I'm a little bit on the younger side myself, and that's usually one of the first things I look for. This is a great way to enhance your benefits and retain and attract some new employees. So this is a really brief overview of benefits pre-funding. And like Kevin said, we don't really have a lot of time to go into specific particulars, just because we're trying to keep it a little bit short. But if anybody's more interested in taking another look at this, or even learning a little bit more about how it works, please reach out to Kevin or I, and we would love to speak to you a little bit more about it. With that being said, I try to keep it a little bit short. I know investing is a little bit of a long process and a long talk most of the time. So with that, I will turn it over to Seth Baronswijk to speak a little bit about HR law right now and how that world is changing and shifting.
Hi, everybody. My name is Seth Baronswijk. I'm the founding and managing partner of Baronswijk Leonard. We're a business law firm here located in the Tysons region, and we practice among other regions in the Washington, D.C. metropolitan area. And the reason I'm here today is to help guide through some really important developments that have occurred both on the federal and on the local level as it relates to HR management. Look, your workforce is the life and blood of the company, and it's critical to recognize that we're living in a historic time. We're in a point right now where we don't have the same access to customers. We don't even have the same access to our fellow colleagues in the office. And like it or not, most of us are telecommuting right now. And there are people that have to take leave for a variety of situations. Congress recognized in the human resource and employment context that there was some dramatic changes that needed to be made and needed to be made now. So they have enacted various relief acts that I'm going to jump in and talk about. And from an HR standpoint, the relief acts immediately came in and created new categories for paid sick leave and paid family and medical leave. Under the emergency legislation, all employees are entitled to 2 weeks of paid sick leave, and as necessary, 10 weeks of paid expanded family and medical leave. That way, there's a recognition that given the fact that people are not going to be able to have business as usual in the office, they have these new protected categories that Congress has provided in an emergency context to make sure that these categories that never before existed are now in place to make sure that there's more flexibility to make sure that your employees are covered. One of the pieces of the puzzle that fits directly into context, though, that we need to be aware of is the fact that as offices are involuntarily padlocked and people are unable to work in the office as in the normal standard and operating course, that we've seen situations where employers are going through some very difficult times from a cash flow and an operating perspective, but they have people that literally can't go to the office and perform work. So what has occurred is Congress in the Relief Acts has also created what can be called as essentially a turbocharged temporary furlough to the state-based unemployment commissions. Under this approach, what the employer can do is they can take their workforce and tell them that due to the need in an emergency context for preservation of capital and the recognition that people through no fault of their own are unable to come to work, they can be placed on a new temporary furlough where they can be put onto the state-based unemployment system, which is supplemented by additional federal emergency revenue, and they can get almost their entire salary paid for an extended period of time until such time as normal operations are back in place. So as you can see, these are very dramatic changes where now people can either have extended new categories of leave, or the company can preserve cash flow, put someone on a temporary furlough. The employee can be on hold. They can get almost their entire salary. And then when the company's back in a position to bring that person back, then they can be recalled back to their employment. So these are things that are absolutely critical and that we need to be aware of as we're running any business. If we turn the slide, we can take a look at the next provision that's directly tied in, that has to do with maintenance of some of the underlying documents that you have to plug in. Because
someone's sending some really bad comments, you need to block them.
When the dust settles and
all right, Bob,
get audited at some point later in time, you want to make sure that you maintain appropriate accounting and HR records at your company to make sure that if the state or federal authorities are coming in and want to make sure that they can have appropriate document trails, make sure that, as we're seeing here in the slide, that appropriate records are being maintained in the employee records. It's a little bit of a balance in the situation, given the unique historic time we're in, because on the one hand, you want to be able to maintain contemporaneous records as effectively as you can. But on the other hand, you have people that, regardless of whether they're suffering from the virus or not, are not going to have the same immediate flexibility to be able to provide all of the documents. So you're going to have some degree of flexibility as a practical standpoint. And there may be other areas where you can maintain the documents to prove the leave-based qualifications. So, for example, if someone's not able to come to work because their children's school has been closed or the governor has issued a stay-at-home order, you can simply print out those forms, those emergency declarations that are publicly available, and those will be more than sufficient to be able to help assist the documentation. But the thing that I think is most important here is to really maintain a level of cooperation and coordination and communication with your work staff, because everybody is under a significant degree of stress at this time, and everybody is really kind of doing the best that they can. So maintain the documentation, but be practical. If you need a doctor's note, someone literally may not even be able to physically get to their doctor's office, so you can get that eventually. If we can turn to the next slide, the one aspect that we need to talk about yet is something that's been near and dear to many people's hearts, and that you've also seen a lot in the news lately, the Paycheck Protection Act, or the so-called PPP funds. We can run through that briefly. The purpose of Congress through this other piece of emergency legislation is to recognize the fact that small business empowers roughly 2/3 of the American economy. And there's to absolutely nobody's benefit to have an unavailability of emergency funds to allow for preservation of capital for small businesses, including credit unions, to be able to survive during this economic crisis. So what Congress did is they created a few rounds of PPP funds, whereby those of employers that have up to 500 or less than 500 employees are able to obtain, through application to the SBA, as being provided by their local bank, the funds that would be available that would be an amount equal to your average monthly payroll times 2.5. And then what happens is you get those PPP funds, you bring them in, you deposit them, you can put them in, you can intermingle them in your same account, or you can segment them into a separate bank account for easier accounting, which is frankly what I recommend. And then over a period of 8 weeks, you can apply what's called the 75-25 rule. 75% of the money goes to payroll, 25% goes to your rent or other associated utility costs or expenses. And the good news is, if you apply the PPP funds in accordance with the regulations, the loan gets converted into a grant. Then you never have to pay it back. although the interest rate for repayment, if necessary, is still low, this is a historic benefit as part of the emergency legislation that Congress has provided you. So if you apply it according to the rules, and if you've also applied for it in good faith, and you receive that money, then it's going to make your life easier. One of the things that we're suggesting to our clients is that you adopt a resolution that is executed by the senior management and leadership of your organization, stating a financial recap at the time that you receive the PPP funds that provides a documentation real time of what the status of your funding was at the time of the PPP, so that a year from now or 9 months from now, if someone goes back and asks you in an audit what financial factors you reasonably relied upon as a basis to accept PPP, you don't have to unscramble the egg or go through an Easter egg hunt. You've got your corporate resolution. It's right there. It has data, and it's an easy thing to tee up. 2 breaking news elements that happen within the next 48 hours regarding PPP. First, there's a safe harbor date, which has been extended to close of business this coming Monday, whereby if anybody returns their PPP because they don't need it, it's a safe harbor, no questions asked. And the feds have said that it's no foul and no question at all. And in light of some of the adverse news that's been coming about, people have been wanting to know whether there's a safe harbor provision. Also, late yesterday, there was a new PPPL rule that was issued by the Treasury Department, a big deal that says that all PPP funds less than $2 million are going to presume to be applied for in good faith and will, other than an extraordinary circumstance, not be subject to audit. This is new. It came out yesterday afternoon, and it's a big deal because small businesses were really splitting hairs and getting nervous about that. And it's something that you also need to be aware of. And it just came out. I'd like to now ask that we turn to my last slide of the day, where we're going to shift a little bit, and we're going to shift from the federal ballpark onto the state law ballpark, and we're going to be focusing on Virginia. This relates to anybody who's either has a principal place of business in Virginia or has employees or contractors that are located in the Commonwealth of Virginia. Up until this coming summer, Virginia had virtually no helpful law from an employment law standpoint. There were essentially no state-based rights. It was really kind of the Wild West. You could misclassify employees. There was really no hardcore protection from a discrimination standpoint. Well, guess what? That's all changed. Effective July 1, sudden huge changes are now being triggered in the Commonwealth of Virginia that's going to really essentially make Virginia the new California as far as employment law is concerned. So briefly, what are we talking about? Under, for example, the Virginia Human Rights Act, there are new state-based causes of action for the whole broad panoply of discrimination for all of the recognized categories, except now you don't have to go to federal court. You can go to state court. There's no statutory cap. You can get attorney's fees. These are brand new cases that never existed before that are suddenly going to be popping up in the circuit courts of Virginia. And we think that's going to be an overnight immediate change. There's also a new law regarding misclassification of employees. For decades, people were misclassified between whether they were a W-2 employee or a 1099 consultant. People flip-flopped those labels. Nobody cared. There were no consequences. They completely screwed it up. And people who were actually employees under the control test were just misclassified, and they were really getting, mistreated. They didn't get benefits. Now, effective July 1, there's a private new cause of action with huge penalties and attorney's fees provisions for misclassification in Virginia. This is going to be a whole new, brand new family of litigation that never existed before. Also, and lastly, Virginia has created a brand new, effective this summer, protection for discrimination with respect to pregnancy and pregnancy accommodation. And not only are these brand new claims that never existed in Virginia, but unlike the other civil rights legislation, you don't even have to do exhaustion of administrative remedies. In other words, in the other cases, you have to go to the EEOC or the local federal employment protection agency like the Fairfax Human Rights Commission, and you have to exhaust those remedies. For these claims for pregnancy discrimination and accommodation, you can go right to court. You don't have to exhaust anything. You can attack the employer right away. These are cases that are going to really catch up from behind and really, I think, surprise a lot of employers in Virginia because it's brand new, it's very fast, and these are all new changes, and they're just weeks away. So in the shortness of time, I'm going to stop there. and turn it back to Gary, but just say that if there are any questions, then on the federal or state level, happy to answer your questions. And now, Gary, take it away.
Great. Thank you, Seth. I appreciate it. Great information. Actually, from everyone, thank you so much. Great information. I'm going to turn it over to John Silverman right now. I know that there are some questions people have asked. I'm going to let him go through those. John, if you just read the questions, let's direct it to the panel and see what we got.
Absolutely. So the first question I'm going to go with is for either Milt or Gary. The question is, does the DC stay affect foreclosures and evictions? Is there any moratorium in Virginia on foreclosures, evictions, or repossessions? What about federal BK courts?
I can take that.
Yeah, I spoke for 20 minutes straight. I'm going to let you take that now.
All right, great. Well, the answer on the DC question is that foreclosures and evictions in DC are in fact stayed. They are considered collection actions, and they are stayed by the DC Emergency Act. With regards to Virginia, there are no prohibitions on foreclosure, eviction, or repossession, unlike in Maryland. And with regards to the bankruptcy courts, the deadline to respond to anything has been extended during the course of the emergency. I believe currently it's 84 days, and that's 84 days from March 15th. Discharges have been continued, and there are hearing dates for motion relief. They won't be scheduled till about June 8th. So much like the state courts, where there's been pretty much they've been working under limited and emergency operations, the bankruptcy courts have been operating much the same way.
All right, perfect. Thank you so much, Milt. That was really informative and great. I'm going to move on to the next question. I think it's also for either Milt or Gary. So regarding the CFPB reporting, you say that accommodations to modify payment terms must be in writing. Are there any guidelines to constitute a writing? Is an email sufficient?
Yeah, I'll take that one. So the accommodation that's talked about in the new rule is not defined other than in writing. But if you look at court rulings, what you'll find is that in writing is defined as anything in writing. So if there's a written accommodation that's in an email where there's a transaction back and forth where an accommodation is requested, it's agreed to, and then it's again acknowledged by the debtor, then that would, there's no case law on this, but we think that would constitute an accommodation in accordance with the new rule.
Perfect. That sounds great. One last question. And again, if anybody has any additional questions, please put them in the chat and I will be reading them. The last one I have currently is, let's see. I think this is going to be for Seth. And it's, can you explain more how it is an economic disincentive for your employees to take family leave to care for a child, and how businesses should make decisions based on this?
Sure. The reason why there's a reference to there being an economic disincentive is because when you look at the math, the money that would be received by the employee on the temporary furlough provision for the new turbocharged unemployment coverage is going to be an amount that would be roughly equal to the full amount of the salary that the person would otherwise receive. However, under the statutory benefits provided under emergency family and medical leave, those benefits do provide payment on a daily basis, but those benefits only equal about $200 a day. So while there is coverage that is provided, there is an economic disincentive, ironically, for people to not go on a temporary furlough status. We've received calls from clients saying, during this mode of needing to preserve capital, we're really concerned about our ability to survive, because if people go on around 10 weeks of paid family medical leave, and we have to foot that entire bill, that's going to have a major impact on our operations, because people are going to be getting their full pay, but they're not going to be helping to drive revenue. Actually, we've told them that they shouldn't worry about that, because in that instance, if they point out to the individual that they can still be home and they can take care of their children and their loved ones, but go on to a temporary furlough status, they'll actually, at the end of the day, get more money doing that, which will be helpful to the employee because they'll be able to get more money, while also being helpful to the employer, because then they won't have a short-term burden on their payroll run. So therefore, it really pays to understand the intricacies of how the leave and furlough provisions work as we're guiding our way through this crisis.
Perfect. That's a great answer. Thank you. There's actually a question I think either myself or Kevin Fitzpatrick can field. I'll leave it up to Kevin's discretion. But the question is, could you explain more about pre-funding benefits can reduce your employee benefits costs and potentially make your employee benefits free? Kevin, if you want to handle that.
Sure. Yeah, happy to, Jonathan. Yeah, no, thank you. That's a great question. And that's exactly what pre-funding benefits tries to do. And it could be a 12 to 24 month strategy to fully realize that goal. But in a nutshell, what you're attempting to do is take permissible investable funds, which are currently, let's say, for example, sitting at 1 or 2%, moving them over to an ecosystem where you can get 4 to 6%, and then you've created a delta there of X number of dollars. And under Regulation 701, by law, you have to use those dollars to offset the cost of your health care. Again, the goal is, can we take enough money to offset 100% of the cost of health care? Sometimes yes in the first year, sometimes no. It might be a 24 or even a 36-month strategy to get to that point. But that's what's very unique about the credit union environment, that they have the ability to do that, that banks and other financial institutions do not. And it's not an easy process. Obviously, it takes some planning, but certainly not insurmountable and eminently doable with time and effort.
Thank you so much, Kevin. And just to add on to that quickly, just from knowing about this is, even if you don't become budget neutral in your first year, this is a great program because it allows you to at least pay for a portion of your employee benefits, where you can then take the money that you were using to pay for those benefits and put it back into other parts of your company and credit union, whether it's hiring, improving your location, or anything of that nature. So it really is a great tool, even if it's not entirely setting off your entire employee benefit spend, to at least try to help mitigate those costs and at least lower them, especially with next year after this pandemic winds down, the rising healthcare costs. And any strategy we are absolutely there to help with and build out for you custom. That's actually something we specialize in. So if you have any other questions, we'd love to help answer them. I think that would be the end of our questions. If anybody has anything else, please let us know.
Great. Thanks, John. I appreciate it.
Thanks, Jonathan.
Yep, that's all the time we have today. Thank you very much for attending. We look forward to scheduling some additional events. We appreciate your time. Thank you for joining us here today. We hope you found this information useful and helpful. In the event you have additional questions, all of our speakers are available to answer your questions either by email or phone. And once again, we really thank you for joining us. Be well, be safe, and we look forward to seeing you again. Thank you.